Welcome to today's program, Termination Consternation, Guidance for Multinational Employers on Managing Dismissals Across the Globe. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the Q&A box on your screen. Now I'd like to turn it over to Tessa Cranfield.
Hi there. On behalf of us all, I'd like to welcome you to the webinar. Thank you for spending your time with us. Quick overview, you'll be meeting us as we go along. You've got a team of 4 today, spanning different offices. We all specialize in global employment law. You have Anna, Sid and Dan Waldman out of New York. I'm in London, and particularly pleased to have Sophia Bargellini with us, who's out of our newest office in Milan. And between us, we cover, we have qualifications in UK, US, Spanish, Italian employment law, but we will do the full range of global law, and that's what we are really focused on. Let's move on to our agenda for today. So, what we'd like to do today, I think, is start by setting the scene. Probably many of you on the call will be based in the US and will be tasked with managing these kind of restructurings, terminations across the globe. So we thought it would be helpful just to give you some insight into what makes the US unique, and out of that, what you really need to watch out for, what traps there are potentially as you deal with countries outside of the US. So we wanted to start there to anchor us. We'll then move on, focusing really on big picture restructuring. So global reductions in force and what you need to be mindful of in terms of planning, what makes those projects successful, and where things can go wrong. And we've certainly seen a few of them between us on the team presenting today. We'll then move on and look at some other common types of termination you may deal with. So individual, that's not mass redundancy, but can still be tricky nonetheless. Performance terminations, often leading into mutual termination agreements, which can come up in all of these contexts, but we'll focus on it there. And then we'll finish up with talking about the context of disciplinaries, where there are some very specific rules in certain countries outside of the US. And we hope that we'll have time to take some questions at the end. So as we go along, please do put any questions that you have into the Q&A box, or if you have something that's more confidential, you don't want to share with all the attendees, of course you can follow up with us separately. But we'll try and leave a little time at the end to tackle any kind of common questions or issues that are coming up. So let's move along and go through together what our goals are for this session. So what are we hoping that you will get out of this? With everything that's going on at the moment with inflation, global challenges, some thinking that we're sort of at the top of the market, and we're starting to see signs of that in our practice. We're going to spend quite a bit of time in the first part of the session looking at planning and implementing restructuring globally, and we will break that down into specific planning issues that it would be good for you to know about, both central when these things come across your desk and at an early stage, and as you take things out locally to specific countries. Some specific challenges that you should come across and trickier situations that you should just have on your radar. We're not going to go super detailed on this, but we want you to have on your radar particular areas where there should be red flags. And we'll come on to that, but we're talking about a context of M&A activity at the same time, of litigation or other issues going on locally. And we'll give you some sort of takeaway points that you can have on your radar where you might need to raise a flag or escalate. We'll cover, because obviously it's not something you deal with so often in the US, the role of works councils and unions and how that fits into the bigger picture. And we'll also give you some slides, which might be reference materials. We won't get too bogged down in detail today, just to give you an idea about managing timelines in these types of exercises, budgets you should be allowing for, and the kind of legal risks that, I mean, hopefully you can avoid with the early planning that we'll be suggesting. And then we'll move on, once we've talked about those large-scale restructuring exercises, we're going to then take you through the other most common types of termination that we come across, why it matters outside the US, whether you terminate during probation or afterwards. And spoiler alert, I'll tell you now that in many countries, if you wait until after probation, your costs can exponentially increase, because in a country like Germany, people can then have special protection and notice periods will go up a lot. So it's important just to jump on those issues, or tell managers to jump on issues, in particular performance, rather than waiting and tackling at a later time. And then we'll focus on performance, disciplinary, and we'll also deal with mutual agreement as we go along. Not always the silver bullet, and again, we'll just let you know some sort of tips for the wary as to where you can't necessarily just come in and offer a mutual agreement at the start of the process, because that can mean you're having to make out a much bigger severance payment to somebody. So we'll tackle all of those, hopefully by the end of the session, and you will at least have an overview of, help you identify what is the right reason I'm terminating here, what process follows along with that, what should I watch out for. That's our goal. Moving on, I'm going to hand over to Dan to set the scene. Over to you, Dan.
Hi, everyone. Thanks for joining us. My name is Dan Waldman, and I want to talk about context, because I don't think any conversation about workplace law to a largely U.S. audience, especially when it comes to talking about employment terminations, it would not be possible without putting the U.S. in context. That's because the U.S. is truly different than the rest of the world. There's just no other way to put it. We're a gigantic outlier. The way I want to sort of paint that picture is if you'll just indulge me for a second and picture something. Picture you're flying through space. The bulk of space is just empty space. In fact, the amount of space taken up by celestial bodies is like, a teeny tiny fraction of the entire universe. Well, what we know in the US as employment at will allows for dismissals for anything in space, except for the illegal reasons, which would be the teeny tiny portions of things that would be the celestial bodies. Now, we all know in practice that it's not that easy, but at least in concept, it's supposed to be that easy. But the rest of the world does not work that way. It's actually the entire reverse. Outside of the United States, where there isn't employment at will virtually anywhere, the only way you can dismiss employees is for specified reasons. So your ability to terminate employees are the celestial bodies in space, and the vast majority of empty space is where you can't terminate employees. So if you don't fit into one of these narrow categories, it's going to be very difficult. And they're sort of laden with complex process and substantive requirements and that go with it. I mean, in the US, the flip side of employment at will is that dismissals come with a lack of predictability and a great deal of volatility from employees who bring claims after the fact. And some things that are different, of course, with employment at will, we don't use employment contracts in the US. Again, that's different than virtually everywhere else in the US. Employment in the United States, when it comes to dismissals, it's largely an individual conversation. Again, we're not talking about unionized employees in the US. I think that's entirely got to be carved out from this presentation, just conceptually, because it would totally change the way we look at this. And separation costs in the US are generally lower, but hugely volatile. So I think that the concept of and we can go to the next slide. The concept of employment at will is what sort of sets the stage here in the United States. And so here you've got some compare and contrast points on this. And I'll give you a second to look at it before we move on to the next slide, please. Thank you. And I just want to point out, so we are going to make some really gross generalizations here, because in our group we regularly are touching on 160 plus countries. So to try to be specific, it would be impossible. So we're going to really generalize. And so, for instance, redundancy, which is the idea of dismissing people outside the United States because their role is no longer needed for some justifiable and allowable reason, which, by the way, as an important aside, I want to differentiate a terminology point that'll help for the rest of our talk. In the US, we talk about RIFs, reductions in force. And reductions in force are a US dismissal of multiple people for any reason. It could be for any reason. But redundancy outside the US has a very specific definition that we'll get into a little bit later. But in terms of redundancy in APAC, for example, the process compared to other parts of the world is relatively simple. The costs are relatively predictable, but however, the legal requirements for that allow for dismissals in many Asian jurisdictions, it's next to impossible to terminate an employee. However, there is a cultural understanding that when it's come time for someone to leave, that they can be induced to resign through payments. And this is a process that we see repeated in some form or another in many Asian jurisdictions. So with that, I'd like to turn over the rest of this to my colleague Anna Sid to talk about LATAM and Europe. Anna.
Yeah, thank you so much, Dan. So as you pointed out, the concept of reduction in force doesn't really match with the definition that we have outside of the US, which is the redundancy or job elimination. Basically, the company needs to eliminate a position. And most of the countries where there is a definition of what this redundancy triggers, it requires kind of an objective economic or operational reason to justify the business need to make the position redundant. So it can be a financial decrease, it can be a reorganization that has proven to be inefficient, or production-related grounds. In Europe, it's really regulated. There are strict rules and process that need to be followed, and it might trigger consultation when it is considered collective, and we will go into more detail in today's webinar. But there are country differences because even though this will all come from European directives that would allow a certain level of consistency, then the interpretation and the implementation in the different countries will vary and differ. Jumping from Europe to LATAM, in Latin America, there's also some countries have a definition of what redundancy is and how you can terminate for those grounds. Other countries don't even have that concept, and it will be considered a termination without cause. Where it is a definition, it might involve some union consultation or discussion, and it might also involve getting the approval from the labor authority or the Ministry of Labor. But in these other countries where there's no such definition and it is a termination without cause, it's similar to what Dan was describing as in APAC. It's basically reaching an agreement with the individual, and for the agreement to be valid, there might be a further step, which is to validate the agreement with the labor authority and or the notary. So again, it varies a lot, and the requirements can be different depending on the countries or the regions, but they have to be linked to the position and the business grounds for the companies, not just we need to adjust the workforce for whatever reason. You have to have these objective grounds that are defined by the law. Next slide, please. So I'm going to hand it over to Tessa and Dan to continue on the performance and disciplinary.
Sure, thanks, Anna. So continuing our kind of high-level view and giving you a highlights of regional differences, When it comes to performance and disciplinary, I had a client, I think, mentioned to me just earlier this week how painful it was going through either of these processes in the UK. I think it's some of the other countries, you know, perhaps continental Europe, France, Germany, Netherlands, and some of the APAC countries, Korea, Indonesia, which have a reputation for being most difficult. But actually, there's a huge amount of process involved in managing performance and disciplinary processes in some countries like the UK. So you can't assume that just because yeah, a country, for instance, is less unionized or doesn't have works councils, that there isn't quite a heavy burden if it comes to being able to terminate at a reasonable cost. And I guess what we're talking about here is, you know, what is the process that is required in order to be able to terminate, which is the case in a country like Netherlands, where a termination otherwise just can't be done without mutual agreement. And what is the process you need to follow to avoid a really excessive, unnecessary amount of severance pay being payable, which might be the case, for instance, in the UK. Contrast that in Europe with, for instance, the Middle East and some parts of APAC, where you're just very rarely going to have grounds for termination. In a lot of the Middle Eastern countries, you know, for instance, Saudi, as I recall, Qatar, really to be justified in a cause termination, you're essentially talking about a criminal offence. So that's very rarely going to be the case. So it's worth just taking stock before you set up a PIP or go down a formal disciplinary process, checking the region and country and thinking, is it even worth going down this process? Is there a point to it in that I think the situation may be recoverable, we may keep the person? Is this going to end in a termination? In which case, in some of these countries, you are better off putting the money that you would otherwise have spent on payroll in following a process elsewhere towards a mutual agreement. And we see that quite a lot. Anna, your thoughts on Europe and LATAM?
Yes. So again, there needs to be grounds that are defined by the law, and we need to look at what the law says in the particular country to be classified as a disciplinary termination or a performance. It might trigger a process, so kind of a progressive process in terms of first warning, second warning, in order to be able to implement the termination, and then ultimately the risk of this being considered termination without cause, because, you know, there's general protection for the employees in both regions in Europe and LATAM, and therefore sometimes you have to balance the risk, and it's just more efficient to open a conversation to a potential mutual agreement. But you know, the initial step should be to follow the process and to have the grounds clearly stated, because otherwise the possibility to negotiate an agreement is going to be much weak and much more difficult.
Right. Yeah, so the two are not inconsistent, actually. Preparing the case, having the ground, even if you're then going into a mutual agreement discussion. Yeah, that's a great point. Great. I think let's move on and focus now just for a few minutes on RIF, as we're calling it, but really sort of role eliminations and workforce reductions. So if we can go to the next slide, please. Dan, could you again just paint that picture for us, US versus the rest of the world?
I guess I'm the painter today, and if you actually saw my artistic ability, you would not like that. So in the US, I know when we're thinking about mass RIFs, any sort of RIF, what comes to the mind of HR and legal practitioners as the oh no is again outside of the union context in the US is the WARN Act and the state WARN Acts. And we all start into this like, okay, how do we count people? What facilities count? How many days? But in the end, it's actually not like there's a lot of technicality to it. But in the end, it's sending a letter to the employees saying that 60 or 90 days from now, your position's going to be ended, and sending a letter to some local officials. But it doesn't, you know, that's really the extent of the obligations under WARN, generally speaking. And so it's not that much, but that I know as a I spent the first half of my career as doing U.S. Labor and employment. Like that, there's a lot of planning that goes into that. But I just want to contrast that with what we see outside the U.S., where this is not a 60 or 90 day advance heads up of the fact that there may be a dismissal coming. Because, like, for instance, I know many people believe that a WARN Act notice, you can continue to give WARN Act notices if you're not certain of when that date is going to be. I'm not sure at all what the state of the law is. We'd have to talk to one of our domestic colleagues, but a collective dismissal in the U.S., the bar is high to even have to do it, and when you do it, the obligations are fairly low. All you're doing is sending a couple of letters, really, and outside the U.S. and a collective redundancy can trigger a tremendous amount of additional process. And what constitutes a collective redundancy in any particular location, it will vary. Again, as Anna said earlier, the way different European jurisdictions have adopted EU directives is a little bit different. But where there are triggers met in some places, that means there is an obligation to inform employees and perhaps an obligation to consult with them as well. There are some unusual elements about how far in advance notice needs to be given. And the purpose of this slide really isn't to get into the details of that, but just to identify this sort of process difference for U.S. RIFs and the much more intricate redundancies that we would see outside the U.S. So for the next slide, please, I'll turn it back to Anna.
Yes, thank you, Dan. So this table basically outlines the difference and similarities within a collective and individual process where it comes to redundancies or job elimination. So it's important to remember that the threshold between the collective and individual redundancies will vary depending on the country. So you might think, well, it's Europe, they have this European directive. Well, no, in fact, the implementation in each country will be different, and also the interpretation of what the law says might vary, and we will get into a little bit of further detail later in the seminar today. But it's not a mathematical formula on just the times and the numbers of employees being terminated, but there might be case law interpreting when and it is a collective redundancy is triggered or not. In short, I would say that the collective process is basically the same process that you have to follow on an individual basis, but adds some additional requirements. And this might be, the key one is the consultation that might be required in most of the countries, which is consultation with employee representatives. Sometimes unions should also be called and be part of the process. And some countries also require the approval from the labor authority. So you need not only to notify, but also to seek for the approval. So it's really additional steps and sometimes additional costs that are added whenever there is a collective process being triggered. Some countries you might have the option to avoid and enter into individual agreements. Other countries, this is really risky. And to name a few, France, Spain, or Germany might be really risky to try to avoid the process by entering into individual agreements. It's just really the consequences might even be reinstatement and high fines. So you have to bear in mind what the thresholds are and make sure whatever process is being picked up is correct one. So moving into the next slide, please. And then the other concept that we have to take into account when dealing in a restructuring in various jurisdictions is that there are many factors that need to be anticipated, and we show here in the boxes a few of them that might come up. This is just an illustration, and we will go into further detail on any one of them. But basically, what I've already mentioned, which is the inconsistent international application of when a redundancy or what are the grounds. Again, even if you would expect certain level of consistency, the the trick is on the detail, and then the implementation might vary and might make this really difficult or really easy, depending on the country you're working on. So the challenge for U.S. multinationals is to ensure that the stakeholders understand that redundancies might have a legitimate legal basis, and these, again, will vary country by country, so we have to look at what are the requirements and the definition for a redundancy ground in every country that is going to be involved, and not just calling at we need to make the size of the business right. That would not be considered a valid reason for a redundancy pretty much anywhere outside of the U.S. Next slide, please. And then I'm going to hand it over back to Tessa.
Thank you. Yeah, and echoing what Anna just said, we've been doing quite a lot of restructuring activity in Russia recently, and I think that's the most extreme illustration of that slide Anna just showed, where even if you've got the legal grounds, the consequences might well be that companies are going to lose assets potentially because of laws that are changing rapidly. So I think that's an example, and that slide used as an example where you're taking the temperature locally, but there's a bigger picture. You can find out what the law says, but actually in practice, are the courts enforcing that? Will anyone be on your side if you need approval from the authorities? Can you trust that they're going to follow the rules? And we're not trying to alarm you in terms of life outside the US, but some of these countries are very different, and we're certainly seeing that in Russia in recent weeks. So again, keeping the focus at the moment on a large scale of global RIF, we wanted to share with you some of our experience, because this is such a large part of what we do. What makes one of these projects successful? So the first 2 points here really are, they're both really sort of planning and anticipating points. There are some reference tools we'll give you, in a second. You'll have slides on this, but really, where do you start? You start by analysing what's the basis for doing this. In particular, are there any red flags in terms of the context, like M&A activity? And we'll come on to a slide that just gives you that as a handy sort of takeaway, what key points to look out for. Then, how does the timing work? We do see often a timeline is laid down that even if legally that may not be a problem, it may be sort of hit and go everywhere at the same time, and that has clear benefits in terms of the messaging and clarity, but we often find that just is not feasible, because there's a lot of work to be done in some countries. Some countries, in particular in Europe, can be very document and process heavy, and it may just be too much to ask of people, especially if the process is being run out of another country like the US. And there's often a lot of planning to do with working out where people are and needing someone on the ground, or sometimes some workaround, giving powers of attorney and so on. So that's not to be underestimated. And it can be too ambitious to try and do everything in one go, in which case, what would be an appropriate phasing that doesn't, in terms of the R consequences for what you're messaging internally. And then a realistic timeline, and in a couple of slides, we've got an example of what that means. But particularly, watch out if you have works councils or you've tripped over that threshold for mass redundancy that Anna and Dad talked about. You're not just talking about potentially a consultation with representatives, which is an information, it's a dialogue. You may actually essentially need their agreement, depending what you're planning. And it might be called an advice, it might be called an agreement, it might be called a social plan, but what that will equate to in a country like the Netherlands or Germany is a negotiation. And essentially, the process can be delayed until you reach terms that the employee's representatives are happy with. There is a process to kind of push the red button and move that to a kind of arbitration, but really our clients want to avoid that if they can. It's not an easy trigger. It still will take a few weeks. So it's building in the fact that if you're in that situation where you need an advice or an agreement, you won't have absolute certainty, after which you can just move forward. So do just bear that in mind. And that's what we picked up in terms of the communicating some of these timelines and issues and restrictions around what people can and can't say will be new to some of the stakeholders you're managing. In particular, some of the senior folks in the US. So yeah, that's something you want to be getting across early, and checking what is being put in writing. Because, you know, under certain countries' rules, like the US and the UK, some of that information would come out in legal proceedings, and it could come out in Europe as well. If people knew there was something, they could request it, potentially through privacy proceedings or as part of a litigation. So, you know, care needs to be taken from the outset. And then in terms of what can make a RIF successful, we tend to see that, you know, what does that mean? It means getting done what you need to get done in a way that minimizes the disruption to business, which could be stoppages. It could be litigation, but it could be as simple actually as retention issues. We've all seen that. The RIF ends successfully, but actually in the meantime, because of the time it's taken or the messaging around it, you've lost good people you didn't want to lose. And that, in a way, is not a successful RIF. It's not what you wanted. And then, of course, it's having met your initial budget expectations as well. And delays and penalties, and I mentioned labour authority approvals, the third-party approvals, that can all again lead into cost and delay. So these are all things that we want to avoid that mean potentially it's not been a successful project. Moving on to the next slide.
Tessa,
we wanted to give you.
Tessa, I'm sorry.
Dan.
I just, can we go back one slide? Tessa made a really good point, and I just want to underscore it, because I would call it, the slide's called key success factors, but I would call it the key avoidance of trouble factor, is this question about what gets communicated internally before a RIF decision is made. What we see, and we see it all the time, is the C-suite goes into the boardroom, and they're looking at the financials, and they're saying, well, the Fed just hiked interest rates by 0.75. We're heading into a recession. We need to start looking to cut costs. So we need to cut 10% of our workforce. That sounds good. Let's write that, you know, and then they put that in writing, and that's from the minutes of their meeting. That is a problem outside the United States. There are many places where the decision to make people redundant cannot be reached without doing certain process steps first. So for the people on this call, right now, executives everywhere, HR leaders are looking at possible reductions in force. Coach the people around you to consider reductions in force, evaluate reductions in force, but not make a decision. No decisions can be reached until the processes are completed. The processes we'll talk more about later, but it's a common error with U.S. companies, and I just wanted to underscore that. So sorry to interrupt, Tessa.
Yeah, no, it's a good point to emphasize, Dan. Let's move on to the next slide, which is just a handy takeaway for you. When you're building the business reasoning, and we know that has to happen anyway from a financial standpoint, this won't be done for no reason. Bear in mind that the level of justification you need is going to vary widely. And on the right-hand slide there, you potentially are going to have to show that the relevant business area, and that might mean the specific local business, is loss-making. In a country like France, it may well not be enough that the group overall needs to cut costs if the local business is not making a loss. So that's one end of the scale where it takes quite a lot of work and finesse to try and put some decent grounds together, even if we know that then we're going to need a mutual termination because the grounds aren't strong enough. Whereas on the other side of the chart, as Dan already mentioned, Asia, Middle East, often redundancy is not even a sort of valid reason to terminate, in which case it's just what you want, obviously, is a coherent story. So employees can buy in, they can accept a context for mutual agreement. And somewhere in the middle, you've got more leeway, but it can't be arbitrary. You will need a justification, but you're not going into kind of the balance sheet issues or the P&L issues that you are for some of the other countries. So that's just a reference point for you. Next slide, please. Again, a point, I'm not going to dwell too much on this slide, but we just wanted you to be able to visualize how the timing might break down if you're doing a RIF in a country that has works councils. And a European works council, for those who haven't encountered it, is where you have 1,000 plus employees in Europe, 150 plus in 2 countries. You may have to have a European works council, which you go to before you go to local representatives. And a timeline of 5 months would not be a bad result, actually, in that kind of project. We've certainly seen them go longer, especially in a large-scale exercise where there's a negotiation about terms with the Works Council, with the unions. So that just shows you how it breaks down. And we also just wanted to bring out the point here that once you've got through negotiation, consultation with the representatives, like a works council or union, you still, in most countries, will then have to have an individual discussion and issue notice letters, have employees sign termination agreements on a one-to-one basis. What we tend to find is that process goes much quicker if you've been through that longer collective process, because there's already a framework. There's a formula for what the severance pay will be. Their representatives have already made points on their behalf. So that's not time wasted necessarily, but yeah, it can be long, and the timeline here is potentially quite an optimistic one. So I just wanted to help you visualize that. Let's move on. Largely for reference, but here are a couple of slides. Next slide, please. Which just warn, so it's on your radar. What should you be watching out for? Dan mentioned already that, take care when you're making decisions as opposed to proposing ideas, getting business buy-in. It may be fine to have already made a decision in one country, but that may be a huge problem where actually you should have gone through a works council or similar process somewhere else. So take care with that. And on the next slide, I won't dwell on this one, but here are some points to kind of watch out for. Very commonly, things are happening at the same time. You're sending a service out to a service provider, you're incorporating an acquisition, you're making changes to terms. Let's move on to the next slide. You need to think up front and make sure you're getting the information you need from the business about what the bigger picture is and what's planned, because there can be a right stage to do things in. And for instance, if you have a QP transfer of undertakings, there's lots of special protection around termination and extra cost as part of that. Whereas if you did your right sizing later on, or potentially well before, you might save yourself a lot of time and cost. So that's a detailed area we won't go into, but just have this as a reference tool. Be mindful that there is a bigger picture going on that can make a big difference to how complicated and how costly your restructuring is. And just to finish restructuring, we wanted to, again, give you some takeaway points in terms of timings and costs. So we can flick on a couple of slides, please. We shared with you the kind of big picture timeline. At the outset, you'll be wanting to think how important timing is. There is a balance to be struck between timing and cost. So you will undoubtedly get through a negotiation quicker if you have a bigger budget to throw at it that you can offer in negotiations, both with the Works Council and in terms of mutual separation agreements. So that's a thought process that you need to go through at an early stage. Is it costing us to even keep this business open if it's loss-making, for instance, versus what is it worth putting into the pot? Be aware that you can't always terminate immediately in a number of countries. Even once you've issued notice of termination in a country like Germany, people might have to stay on payroll for 6, even 7 months if they've got long seniority. So do bear that in mind. If budgets and announcements to the market are dependent on saying people are off payroll, that can be a problem versus having confirmed that you've got a process underway or potentially that you've issued notice of termination. Those are quite different things, in particular from a European standpoint. Also, in terms of issues that go into timing, just bear in mind that other exercises you have going on could feed into the mix. And let's go to the next slide, because it can be quite commonly forgotten that if you've already had a recent wave of restructuring, those terminations can be brought into the mix and working out whether you've tripped over a mass threshold. And there are also, in a number of countries, in particular in Europe, lockup periods. So if you've had a first wave of mass dismissals, you may find there is a period after which you cannot terminate again. So do make sure you've got that information. Some of that information might be held locally. Similarly, if you've got a bit of leeway with timing and can stagger terminations, you may find that you've got leeway to avoid tripping that mass termination threshold, which might be, say, 10% or 20 employees. So if you can get in there early enough and have that conversation with the business, you can potentially save yourself quite a lot of process and some pain. I would just finish up, if we can skip forward a slide, and again, please, thank you, just to give you this reference tool. So as you're planning costs, what kind of costs might come up? one point I will pick out from this slide, not all the severance policies and costs that you might face have been agreed at company level. Some can be imposed on you just because you belong to a certain sector. And you may not necessarily know, you may not have a copy within HR or legal, for instance, of what the collective bargaining agreement or CBA for that sector is, or collective labour agreement, for instance, in the Netherlands. But bear in mind, just by dint of the company being in a certain area, that will apply, and it will generally involve cost and potentially process. So that is a key point to check up front. And the last point, a takeaway point, we just wanted to recap by region what kind of costs would be typical, what can you expect. I won't talk through that, but these, I hope, are just helpful for you to take away and refer back to when you need it. And I will pass over to Anna, who will start, I think, with the all-important code. If we can have the next slide, please. And one more. Thank you.
Yes, so before we move on, I'd like to provide the CLE code, which is required on the CLE verification form that will be emailed to you in a few days following this webinar. So the CLE code is SS7251. That is SS as in Seyfarth Shaw 7251. I read it once again, SS7251. Now back to the program. Next slide, please. So in terms of the individual redundancy or role elimination, even if the threshold is not triggered for a collective redundancy, there might be some process that might be triggered and some consequences in terms of delays or even additional costs if you don't have it, right? So sometimes paying an extra amount to the individual employees might be a solution, but in other countries or in certain situations, that might not be really the end of the story. Next slide, please. So the first thing we would look at is, again, the threshold for the collective redundancy. Why is it important? When, as Tessa was saying, there's this threshold and it varies country by country, and sometimes the stage during the termination, so just delaying some of them to avoid the process might be a solution, but there might be some case law in the countries, as I referred to earlier, where, you know, if the threshold is 10 employees in the period of 90 days, and you're doing 9 terminations, and then after the 90 days, another 9 terminations, if these were planned beforehand, there might be some case law that says, well, in some countries we've seen that are basically considered that this is fraud because the company knew from the beginning that the threshold will be exceeded, and then therefore planning this in advance just to avoid the collective process might be considered fraud, and therefore terminations would be unfair or without good cause. And in some countries, this might trigger the re-obligation to reinstate the employees and therefore start all over again. Then the other thing that I'm going to touch upon is the selection criteria, which is well defined in some of the countries, in other not so much. So it's more to avoid discrimination. But because now we're talking about individual employees, so it's not a collective process where you just include a number of positions and globally a group of employees, this is just for an individual, then the selection criteria becomes more important. And we have to look at the different laws, and Tessa referred to, so I'm going to go very quickly, but it's not only the local law. You might have collective agreements. So the fact that you haven't negotiated your own collective agreement for a company doesn't mean you don't have one. It is very common, particularly in countries in Europe, where, you know, there's an industry-wide collective agreement that the unions of the sector of the industry have negotiated, and that will widely apply as a source of law to all the companies within that sector. So that will be binding. And then also some past practices and references might have to be looked at, because you know, if there has been a collective redundancy recently with certain terms that have been agreed under a social plan, the fact that you implement an individual redundancy shortly after, that might trigger that, you know, it is considered that this individual should have been included, and therefore a similar package to whatever has been agreed under the social plan should be offered. And this is something that sometimes is known locally. There has been, Tessa was referring to the period where you cannot terminate, but there might be agreements under the social plan where they say, well, and if you terminate because there are new grounds, then you guarantee the same conditions that have been agreed under the collective process with this individual. So again, looking at the past practices and background information is really key to this process, because even if it's individual one, it might trigger some additional risks. Next slide, please. The selection criteria I was referring to before, it varies by regions, and I think mainly in Europe this is more regulated. The general rule, let's say outside of Europe, might be, avoid discrimination, and therefore, it might be in APAC, the last in, first out, but other than this discrimination grounds is basically not so regulated, where in Europe there will be a selection. Can we move to the next slide? Here it's a bit more visual. So you have some good group of countries where you will have a selection criteria that is more based on the job position. So we are talking about the position of the employee and why this position needs to be elimination. Other countries will have a combination of objective criteria plus social criteria, those employees that have some family commitments, some other circumstances. And this is sometimes a result of what has been negotiated with under the collective agreement or social plans. So that's why it's important to have that background information, because the selection criteria might be set up there in these internal rules. And then there are other countries where there's a mandatory criteria that is set out by the law. So again, sometimes business will have a set of list of employees that they want to apply and they want to terminate. And sometimes what we do is trying to look at that list and work backwards to see if the selection criteria will work. Next slide, please. Sometimes it's not even possible. So there might be some protected individuals that just cannot be included in the process, like employees representatives that will have a priority to stay. So basically, they will be the last ones to leave. So it's really important to have the selection criteria right. Another group of protected employees that is quite obvious is the maternity or paternity-related grounds, and pregnancy, maternity leave. In those cases, it doesn't mean you cannot make the redundancy. It just has some additional complexity because you really have to demonstrate that is that position the one that requires to be eliminated and that the decision is not related to whatever the protection criteria is. And then other individual issues that I'll touch upon very quickly on this slide is, even if it's individual, it might trigger consultation with the employee individually or with employee representatives that you have to notify beforehand. So notification is mandatory in some countries to Works Council or to unions when the employee is a union member, or even if the union has representation in the company. And that will, it's a relevant part of the process. Also, some countries might require to look at reemployment. So if there are any vacant position elsewhere, and you have to see how far you have to go, because it might be not necessarily in the same employing entity. Maybe a group company has to be looked at. So the company might be obliged or might be highly advised to offer this additional position, and then look at other options, because like in the collective process individually, there might be some things that the employees are keen to accept when it comes to an individual termination, like, I don't know, outplacement plans, or keeping certain benefits, or having access to some other, and we'll see this a bit more in detail when we talk about the mutual agreement, but having access to certain benefits that will vest right after the termination might be some other things that we want to look at the individual terminations. Next slide, please. So other than redundancy, individually, we also have the performance and mutual termination that I was referring right now. Next slide, please. So again, we have to look in the performance termination. So basically, you're terminating an employee for poor performance. This, I have to say that globally, my experience is that the majority of the countries don't have a set process for that. This is considered rather conduct issue that instead of performance. So the employee is not performing because they just don't want to, and therefore it is a misconduct rather than being classified as the employee not performing, and you go through the process. And I'm going to ask Tessa to give us an example on the UK, because I think it's the one country that has a really set procedure on how to manage performance and how to be able to terminate employees due to poor performance. But other than that, again, it's important to look at the local laws, what they say, and collective agreements, and any precedent practice or past practice in terms of issues with performance, because it might be that this is treated as a disciplinary process that our colleague Sophia is going to guide us through, but it's kind of a different stages that need to be followed in order to implement determinations due to poor performance. Next slide, please. in any case, it's really important to collect the evidence, to check the performance is comparable to other employees. So, we look at what is the standard performance and what is the performance of this individual employee, what has been the previous performance and what is the current one, in order to be able to demonstrate the decrease. And then before I hand it over to Tessa to tell us about the UK, there's a couple of things I want to flag because I think are important in this managing the poor performance, and that we find all the time when we're advising our clients is, first, what has been the communication in the past? So sometimes we want to terminate an employee for poor performance, but then we look at the last evaluation or appraisal and it is positive. So, or the employee recently had a salary increase or a promotion. So we have to look at that. And then other risk factors. So that maybe the employee has been on a leave of absence or has some medical issues or has raised a concern because of harassment, and that might be impacting the performance. So all these things will come up, and because this is considered in some countries as disciplinary, then these will all be raised by the employee in a potential litigation. So it's important before going into a performance process to look all the context around it and to make sure we're not getting into one of those situations where the employee might be protected because they raise a complaint and hasn't been investigated, or there's a precedent or local policies that set up a particular process that needs to be followed and that the company hasn't followed. So Tessa, if you can quickly guide us through the UK example of managing performance, please.
Yeah, so just using the UK as an example, as Anna says, your starting point would be a PIP, which is familiar to many people on the call from the US as well. I think the key difference with the UK is that then needs to be followed by a formal warning, and it's essentially like a disciplinary procedure. So it's a formal meeting, basis for decision, written warning, and a right of appeal, and that really should happen twice, unless the conduct is, really, really egregious. And as Anne says, there's always a call to be made as to whether, in fact, you treat it as a disciplinary, which often is a bit of a quicker process. You don't have to have these kind of smart targets and give people a month or two each time to improve. Or in fact, whether you move into a mutual agreement, which Anna will touch on next, the risk being that if you go straight in with a mutual agreement, it's very easy for employees in most countries, but especially the UK, to say, well, the whole thing is a sham. You already made your mind up. So how you present that is a tricky one. And if we go to the next slide, I think Anna is just going to touch on that.
Yes, so we've included here, in these situations, in redundancy as well, but when managing performance, well, the obvious question that comes up is, are you ready to offer a package? Because the process is complex, the law isn't clear, the evidence is difficult, so maybe we can negotiate an agreement. It has some pros, so avoiding the delays, avoiding the process, avoiding the discussions, bringing in the discussion the works council or the union, but it has some cons, which is, as Tessa was saying, if you offer these very early in the process, what's the process? So you already wanted to terminate. So the whole redundancy performance management is really a sham. And then the other thing is the access on benefits. In some countries, the benefit that you would have in a case of involuntary termination in terms of the severance tax treatment or access to allowance, like unemployment allowance, will be triggered if it's a termination, an involuntary termination, but not if it's a mutual agreement. So you have to see what the strategy should be in those countries in order to make this attractive for the employee. Also, mutual agreement in a performance case can be a precedent for future terminations. So future employees might say, well, I know you did this in the past, so why don't you offer the same package to me? And then we have to look at other benefits that might be triggered, as I was saying. So the employee might have access shortly after the termination. So timing is important here. If they are expected to have access to some incentives or RSUs, and this termination will have an impact on that, then it's something that you have to look at because it will come up in the negotiation of the mutual agreement. And sometimes, if you wait a little longer or you give access to those benefits, you might be quickly simplifying the process. And now, next slide, I'm going to hand it over to our colleague Sophia to guide us through the disciplinary terminations.
Yeah, hello everybody. So thank you for your time. I will go very quickly through our last type of dismissal. So dismissal for disciplinary reasons. So differently from the US, in the rest of the world, we don't necessarily, our necessary concern is not on a disciplinary claim, because there are few key principles that all around the world must be respected to deal with disciplinary termination. Next slide, please. So what are the key principles outside the US to deal with disciplinary termination? So the first one is the existence of valid grounds to proceed for disciplinary reasons. So where the valid grounds are set normally by the law, or by the local practice, or by the national collective labor agreements where applied, sometimes also by internal policies or internal rules. Second point, a fair process. It's really important outside the US to follow a fair process where stated, and normally it is, by the local law. So it's really important, and we will see it under the Italian example, because differently, not following the fair process stated by the law, the dismissal would be unlawful. The timing, it's a key essential point in many countries. Timing for proceeding when a fact is found out, comes into light. It's really important in many countries to be really prompt and to act immediately after you become aware of what happened. So, for example, in Italy, bearing in mind, I'm an Italian lawyer, so there's no a strict deadline to go on. There is no strict deadline to proceed after the fact is aware. But, for example, in Mexico, the company must proceed in 30 days. They become aware of the fact, which means that the company should be able to demonstrate that not only higher managers, but also lower level managers were aware, have become aware of the fact in the last 30 days. So timing for proceeding is essential. I want also to underline special cases like union representatives subject to disciplinaries. It may be considered a discriminatory action against unions, or, for example, a person who recently raised a speak up subject to disciplinary action may be seen as a retaliation in many countries. What it is important to underline is also that which is the local practice, which are the local law, and for example, where the threshold for acting for disciplinary reasons against an employee, if the threshold is really high, or maybe a disciplinary action may be granted also in less serious misconduct. For example, in the Middle East, it's the threshold for proceeding for a disciplinary termination is very high, and in Saudi Arabia, for example, they require it's like a criminal offense. I think, yes, please change slide, and just an Italian example, why it is so important to look at the local law and the local practice. It is really important to have a look at the local law, because sometimes, for example, like it happens in Italy, the procedure is essential. And the procedure is essential because it's really, really strict. So the complexity is not because you can terminate for disciplinary reasons in Italy, but what you must absolutely be aware of is the strict deadline that you have. For example, I don't know why the next slide isn't coming. However, I can simply explain thank you very much, what the Italian process is. So the disciplinary termination, so the disciplinary action, everything must be handled in writing from the company's perspective. So a notification letter, the employee can then provide us with his or their defense in 5 days in writing, or ask for an oral meeting, and then the company must issue the sanction. Some CBAs ask for a strict deadline also for issuing the sanction. For example, 10 days after the employee has filed his justification. So dismissing for disciplinary reasons in Italy is possible. sometimes also for not so serious grounds, but the deadlines are so strict that you must be super aware, fully on the loop, just not to leave a chance to proceed for misconduct. Just one more minute, next slide, please, just for wrapping up. And so what we learned today. So the very last slide for you today. So what we understood today. First of all, I want to underline that in all the types of dismissals, we understood the importance of sometimes negotiate or find an agreement with the employee's representative or also with individuals. So what is really, really important is look at the local law, look at the local practice, and also at the local market, because sometimes negotiating or finding an agreement is essential in the local country, and this means that you should have set up a proper budget. So 4 key points for you under this webinar today. The importance of knowing the reasons and so understanding both under a collective redundancy dismissal RIF, both if you decide to proceed with an individual dismissal, reasons are essential. So just have a look at the local market and understand if the reasons you want to pick up are fine under the local law. Know the process. So have you seen the most important, and also from the Italian perspective, most important kind of dismissal where the process is essential is the mass dismissal RIF redundancy, so a collective one. However, as we saw for the Italian case, or in sometimes also the individual ones require a very strict process, and so a procedure that must be handled with. Plan, timing, and cost. So plan timing means having a project and plan it over the months you have, and also a fair budget. To set the budget, however, the local market will necessarily be look in detail, because, for example, severance termination can be different from each country. Know the variables. So timing can be impacted. Sometimes, as we said before, government, the authorities may give their approval before we proceed. So a delay may not be necessarily linked to the employee's termination itself, but also by the intervention of the authorities. So bear in mind that allow your time to be a little bit longer than what you would need, because it may be that something comes up. Budgets and mutual termination agreements. Budget can raise if, for example, employees are stronger or unions are tougher than what we predicted before. The employee's reaction. In several countries, strikes can be called properly because the company decides to reduce the workforce. So the strike in many countries may be an issue, and so this may cause problems, not only problems, but also, for example, not only problems for the termination process, but also for the image of the company and the ER consequences and so on. So I think I ran 4 minutes late, so I thank you very much for your time, and I think Dan, Anna, Tessa, are we running? I don't think we have time for questions today, so maybe.
I think that's right. Sophia. I see one interesting question come up. Please, if you have questions, send them to us separately. We'd be happy to have a conversation with you. As you can see, there's a lot to this topic. We find it fascinating. It's something that keeps us very busy. So if there's something in particular on your mind, we suggest you reach out to one of us or your usual contact directly. We'd be happy to help. And yeah, I think we all thank you for your time and sticking with us. So many of you sticking with us even 5 minutes over. We appreciate it.